Good afternoon. We have 3 appeals on this afternoon's calendar. We'll be starting with appeal number 5, matter of Juarez versus New York State Office of Victim Services. Good afternoon, counsel. In the matter of Juarez versus New York State Office of Victim Services, counsel?
May it please the court. Good afternoon, your honors. May Owen Demuth on behalf of the Appellant Office of Victim Services, may I please reserve 3 minutes for rebuttal?
You may, Mr. Demuth.
Thank you. Your honors, the office's 2016 regulations modifying the availability of attorney's fees during the administrative claim process were both authorized by the agency's enabling statute and rationally applied here. They were
Counsel,
authorized.
may I interrupt you for a moment? If the attorney's fees are only recoverable for administrative reconsideration or judicial review, are you eliminating recovery of attorney's fees in the majority of the cases that find their way to the board?
Yeah, as a general proposition, that is correct, because we're talking the only stage at which they're limited is the initial stage of the claim, which I think is very important to explain right off the bat what that initial stage entails.
But my concern is, are we then out of sync with what the legislature intended here to assist people in rewarding reasonable attorney fees?
Oh, not at all, Your Honor. The question, of course, and when there's an ultra vires argument made like this, is whether there's a sufficient statutory predicate for the regulations. And here there is, because of the reading together the plain language of Executive Law 626.1, attorney's fees must be reasonable before they can be awarded. And in conjunction with Executive Law 623.3, which gives the office the authority to promulgate rules for the approval of those types of fees. So together, we have the sufficient statutory predicate. We know from this language that the office has the power not only to determine whether—
Judge, if I may ask a question.
Yes, please.
Thank you. Counsel, but isn't the problem that what you've done is decide, and this is apropos of what the Chief Judge has asked you, decide that there is an entire class of conduct and fees that is unreasonable. You've made this per se rule, as opposed to, as your own regulations indicate, looking at a variety of factors, kind of the lodestar approach that we see on the civil side in civil rights cases, to determine whether or not the request, the demand for the fees is reasonable. Instead, you've made that determination up front without any information about a particular case. Isn't that really the problem with the approach that you've taken?
Well, I don't think it's a problem, because again, whether it's authorized under statute talks about, is there anything that prevents the agency from using it? And here it's supported by 2 different grounds: its own experience in determining, after years of processing, reviewing, and awarding thousands upon thousands of claims. And again, I should point out, this is in the record. It's a 4-page pre-printed form. It's not a pleading. It's not a brief. There's no need for the claimant to present an argument.
Well, counsel, that may be grounds to determine in any particular case that the amount of the demand is unreasonable, or that a lawyer is not necessary. And if the lawyer is seeking their own fees when they have other people in the office doing it, perhaps that's unreasonable. But again, and we have it in the record, there may be cases where it's not going to take a few minutes to do the form. right? They may very well be more involved. And what you have done is make it impossible for that kind of case for in that kind of a case, excuse me, the victim to seek attorney's fees for that.
Right, but they didn't just come up with this pull this out of the air. They did it based on agency experience, which does count, and which, consistent with this court's line of precedent, can justify the regulations with a sufficient.
Why can't you just take it to the legislature? It seems to be a policy choice. Why doesn't it go to the legislature as a third department mentioned in its writing?
There's no need for it to go to legislature. The authority is right there in the statute. Reasonable attorney's fees, I know you're concerned about, it's true, under the old regime, they reviewed applications on a case-by-case basis. But the important question here, is there anything in the statute that compels, and of course this was the big concern of the third department, compels attorney's fees to be paid at all stages of an attorney representation?
Judge, may I ask a question?
Sure.
Yes, Judge Stein?
Mr. DeMuth, would your argument be the same, or would it be as strong if there were not these victim assistance programs throughout the state? And has that changed anything from when the earlier regulations were promulgated? Is that different?
It's very different. And I in answer to your first part of your question, I think we would, even if we were just talking about agency experience, and here we have two grounds. We have agency experience and the expertise, which is, as you just referred to, the office's creation, funding, and training of this extensive statewide network of VAPs. If we just had the experience alone, I think that's enough, given the ultra vires standard. But we do have these victim assistance programs.
How many are there? And how many are there, and who pays for them?
There are 228 at the moment. They receive funding from both the Federal Victims of Crime Act and also from the state Criminal Justice Improvement Account. And contrary, I know this was one of the affidavits that petitioner submitted states this, but they do not primarily come from general taxpayer funds. They are primarily funded by fees, fines, and surcharges that are paid by persons convicted of federal and state crime.
But do they impact how much money is available to go to the victims directly for their expenses reasonably incurred, as the statute says?
I'm sorry, do they impact?
So does the cost of the VAPs come out of a budget that OVS has that has to be, delegated to either victim direct expenses from the victim, from the crime, versus counsel fees or something else?
No, they come from limited sources of funding, the VOCA, which is the federal statute, and they fund not just the VAPs in their capacity of helping to fill out the claim form, but all of the different services that they provide, and they run the gamut across the state. From
no, I understand that, but I don't think I'm making myself clear. Is if the money was not spent on the VAPs, would that be more money available to pay attorneys? Or conversely, if more money was paid to attorneys for attorney fees, would there be less money available to go directly to the victims?
I think, as a general proposition, that is true. The more money that would be paid to attorney's fees would be less money that would essentially go. But
Judge,
there isn't really a funding.
may I ask a
problem.
question?
Yes.
Yes, Judge Fahey.
Thank you. Judge Stein makes a good point, particularly on the policy level, but if we're restricted now to just a pure statutory interpretation of the meanings of the word shall and the meaning of the word may, how do you get around the shall part of your new regulations?
I'm sorry.
The original regulation says shall grant reasonable attorney's fees. I think it's fair to say that the word reasonable gives some discretion to the agency, as it properly should. But right. Shall grant reasonable attorney's fees means that it hinges not on whether or not a person may use an attorney or an agency, but the shall part takes away all discretion from the agency, and that was the legislative enactment is in the executive law. Where does the agency give the authority to make that shall a may?
I don't think that's in conflict. Are you talking about shall as it's used in 626.1, Your
Yeah.
Honor?
Yes.
Well, our argument, of course, it's as the third department read it and as petitioners would like to read it, it just means shall include attorney's fees, just at every stage, even though that's.
Well, let me stop you. I'm not arguing that. What I'm saying is I do think you have some discretion as to whether or not the attorney's fees are reasonable. If an attorney came in and charged $500 an hour for this work or tried to get the agency to pay for that, it's patently unreasonable, and no one's going to say that you were acting outside of your specific powers that were set out in the statute. But if you were to say they shall not get any because there's a form that they can rely on from another not-for-profit agency, that doesn't seem to be your call under the statute.
Well, I respectfully disagree. Again,
Why is that? How do you get around the shall? And where do you get the authority to say may?
It's, again, shall, and the reasonable attorney's fees, as we view it, as the office interpreted, means not just on a case-by-case basis, is the amount too much or is it too little? There is nothing in the statute that prevents them from also, as long as they have a rational explanation for it, based on their experience, and of course with the victim assistance programs pitching in to help, from also determining that, look, we've done thousands of these claims, it's a 4-page, all it asks for is basic factual information.
No, I understand that. I'm not, actually, your policy argument makes all the sense in the world. I'm not arguing with you about that. Okay. What I'm saying is this is a matter of pure statutory interpretation for this court. Right. And that requires us to say that if we're to agree with you, I think we would be saying that the word shall can be substituted with the word may. And that seems to be something that we don't normally do.
Chief, if I may.
Can I just get an answer from Mr. Demuth first?
Yeah.
You're right, Your Honor. If we were stuck with 626.1 by itself, it'd be a tougher argument to make, but we're reading it in conjunction with 623. And the fact that there's, reasonable attorney's fees and office, you will decide, you will promulgate the regulations when such attorney's fees may be approved. Now this, as we argue, it extends not just to individual claims, which of course was the old regime, but there's nothing in the statute that compels them to impose a categorical limit. And the case law, I think the two cases that we cited in our brief that best support this, even though they don't talk about attorney's fees, they're a different issue, are the Bernstein v. Toria case and the Seghetti v. Ingraham case. In both of those cases, it was a very similar argument. In Seghetti, it was a department, in Bernstein, it was a Department of Social Services regulation that imposed a flat grant for shelter allowances across uniformly applied within each district across the state. And the argument the petitioners made to challenge the reg is very similar to what they're making here. No, you can't do that. You don't have the statutory authority. You have to apply it on a case-by-case basis. This court flatly rejected that. So said, no, the statute may be silent, but silence alone does not create a conflict between the statute and the regulation. So
thank you for your answer.
Okay, Judge Feinman? Judge Feinman?
But following up on Judge Fahey's question, if I understand your argument, it's not that you're trying to read out the word shall, it's that it's how you're interpreting reasonable.
Yes.
Okay.
Yes, absolutely. We're not just looking at reasonable attorney's fees as previously was looked at, but on an individual case-by-case basis.
Right. So you're
using agencies. Right.
You're looking at reasonable in a different way.
Right.
But, I just want to come back to the point that Judge Rivera made at the outset, which is, can you point to any other examples where there has been a sort of determination that a category of fees or claims are not going to be reasonable?
If you're asking me for another attorney's fees case, I couldn't provide you with one, but I don't think that provides the standard review. Being an ultra vires claim would be the same. You first look at the statute. Is there anything in there that's completely contradictory? Anything in the reg that's contradictory to the statute? And then having decided that there isn't, you then look and say, well, is there a rational basis? And here we've checked both of those boxes because we have the language. Again, the third department read so much in the fact that it was silent, and they didn't like the fact that there was nothing one way or the other talking about the stages of a claim. But the reality is, and agency experience does count, the reality is they do these claims on a regular basis, and it's been their determination that it simply doesn't require, in general, attorney fees are not awarded for routine clerical tasks. And that's what the completion of this form entails. And to the extent that there's a special claim, a rare claim, a vulnerable claimant who needs extra help, the office specifically contemplated that situation when it created and built up this incredibly successful network of VAPs. And the third department simply gave short shrift to these VAPs. They simply said, well, you know, they may help in some cases, but for them to determine that they're important in helping with the claim process.
But if I can ask a question, please.
Yes, Judge Rivera.
Counsel, what percentage of the victim applicants apply by using the VAP?
It's quite a lot. Over the last 5 years, it's about 85%, I'm told, of all claims are submitted by victim assistance programs. Not to mention
and did I correctly read the annual reports that the main or the largest number of the denials are based on either the failure or the lack of sufficient documentation to support the claim?
I think that's correct. They had a breakdown in the report.
Does that differ between someone applying by using services at a VAP or a lawyer? Do you know?
No, I'm afraid I don't know that. But right, that is the main reason why it's denied. The person, there's not a lot that you can put the claim in first. And I think it's also important to point out this is not like a claim filed against the state. This is not an adversarial process. The office is only interested, especially at the initial stage of the claim, in obtaining information.
Chief, I have a question, if I might, on this point.
Judge Wilson.
Counsel, the way I read your regulation 52513, it would allow, or it does allow, an applicant whose claim is denied to submit additional evidence. Is that right?
That's correct.
So in theory, I, an unsophisticated person, could file your 4-page form. My claim might be denied. I could engage counsel. Counsel could provide whatever, counsel deemed was missing, and you would have to reconsider that evidence on the motion. Is that right?
That's right. You could put
and I could get fees for that.
Right. That's the so-called reconsideration stage. And yes, fees are available at that stage. That's that's obviously, that's when the hearings take place, if there is one. That no one's saying that you wouldn't an attorney would not be a valuable resource.
Chief, may I ask a question?
Yes, Judge Garcia.
Just quickly, would this regulation pass muster if you had prohibited all fees, including for this reconsideration motion? Would that violate your statutory authorization?
I think we'd have a real problem, Your Honor, because the phrase representation before the office contemplates that there would be, some kind of proceeding that would be eligible for attorney's fees. In which case, here it's reconsideration. So, right, I don't think the office could lawfully be a real problem defending that if they cut out fees except for judicial review.
Thank you, counsel. Counsel?
Yes, Your Honor. George Carpinello, Boies Schiller Collectioner for the respondents. Your Honor, I think the appellate division got it exactly right when it said that the office has literally rewritten the statute. And we put a chart in our brief that shows how they took words out of the statute and put words in the statute. And I think Judge Rivera is correct when she question posed, I think it was Judge Rivera that said, wouldn't this eliminate the vast majority of claims? And absolutely it would, and counsel conceded as much. At one fell swoop, they're limiting the vast majority of claimants getting attorney's fees, despite the fact that the legislature was very clear that attorney's fees are allowed, reasonable attorney's fees are allowed for representation before the office.
Chief, may I ask a question?
Yes, Your Honor.
Counsel, is this case distinguishable? Judge Feinman, I believe, asked whether there were any other cases of this nature where some something was categorically precluded. And I'm wondering if you can distinguish this case from Regan, in which the statute directed the Crime Victims Board to consider all the claimant's financial resources, but the board adopted rules which exempted various resources from consideration. And I believe that was upheld. How is this different from that?
Right. Regan's directly on point. Regan, the court said, this court said in Regan, the predecessor of this agency had a statute that says, in order to be qualified for the award, you had to establish financial hardship. And the board said, okay, well, we're going to say we're not including the following categories of income and property in hardship. And the court said, where did you get that from? And the court said, that's not in the statute. You're acting ultra vires because you're changing the definition in the statute for whatever administrative convenience or for whatever reason, you're changing the plain language of the statute. And by the way, there's no deference to the agency in this case, because what we're talking about here is plain English. There's no technical issue here. They're changing the terms of the statute.
Well, the term reasonable, would you not agree, might require some expertise in terms of what is reasonable in this scheme, in this reimbursement scheme of this agency.
Exactly.
I guess, it's whether you're talking about shall or whether you're talking about reasonable. But if you're talking about reasonable, it seems to me that the expertise of the agency, has some relevance here.
Well, 2 points. Number one, the term reasonable chosen by the legislature has some meaning in the law. And reasonable fees have always been interpreted under the common law, as we say in our brief, as a case-by-case determination based upon the difficulty of the case, based upon the experience of the person, based upon
would you agree that if you sought fees in a case that a judge reviewing your request for fees might say, this work that you're charging X dollars an hour for or whatever, this can be done, it doesn't have to be done by a lawyer. It can be done, say in this case, by a victim assistance person. It's not legal work per se, and based upon the nature, the nature of the work really is what we're talking about here.
I have several responses to that, Judge. First of all, let's take, for example, CPLR Article 86, which says if you bring certain cases against the state, you're entitled to attorney's fees. Let's say the administrative board adopted a regulation that said, you know what, election law cases by their very nature are that's not reasonable, because the statute said if it's unjust or the state's position is substantially justified, that begs for an individual determination in these cases. And if the administrative board said, we're going to cut out a whole category of cases, that would be ultra vires. If the judge in the case you gave said, what you did in this case does not merit attorney's fees, that would be reasonable. By the way, what people do in these cases does merit attorney's fees. The form may be 4 pages long, the statute's 40 pages long. And if you look at the statute and you look at the qualifications for getting recompense under this statute, you definitely need a law degree to figure out. For example, you cannot make a claim 1 year after the commission of a crime or discovery of the commission of the crime.
Well, Mr. Carpinello, how about the fact that here, I understand that one of the claimants had some extraordinary emergency expenses that went to over $1,000, but the other claimant was seeking fees of, a couple of $100, or that's what the board determined was appropriate. So, isn't that something that can be considered in terms of the difficulty of the work, and can't they make a determination that it just isn't that difficult to file this form? There may be other considerations, and yes, if you get denied because you don't understand the whole statute, then you go to the next level and you get a lawyer. Well, and it doesn't seem that there's any prejudice to the victim for doing that.
Well, first of all, the very examples you gave prove our point. In the Soriano case, you'll see all the different things the lawyer did. He got HIPAA statements, he got crime victim statements, he got the domestic relations stuff. Under this law, under the statute, he gets nothing. Just like the person who submits a claim for $250 gets nothing. Now, if the board said the person who submits $250 gets nothing, but the other person gets up to $1,000, that would be reasonable fees. It's not reasonable to say none of them get nothing under any circumstances, which is clearly inconsistent with the statute.
But would it be reasonable to say that the cost of determining 85% of these are decided on the initial claim, right?
No.
No?
No. What this 85% statistic he gave you was the number of people who go through the VAP, which is, by the way, spectacularly unsuccessful. We cite in our papers the fact that the VAPs, almost every VAP has less than 50% success, some as low as 10, 15% success, and they're getting millions of dollars. In any event, whether the VAPs are there or not is a policy decision for the legislature.
Chief,
They're the
may I
ones.
ask a question?
Yes,
Chief,
Judge Garcia.
counsel, what if the rule were to have been they capped attorney's fees at this stage for $50, $50 cap for filing an application? Would that violate the statute?
Absolutely, because the statute says it's 1,000. And by the way,
Yeah, but it just says it's 1,000 overall for everything. I mean, what if they said $50 for this initial phase of filing is the cap?
there's no statutory authorization for that. If the legislature.
But it's not authorization really so much we're talking about here, right? Is this inconsistent? Would that be inconsistent with the authorization they have?
Yes, because the legislature said two things. Number one, you can get attorney's fees, reasonable attorney's fees, and they said up to $1,000. And by the way, Judge Wilson asked the question about if I lose, can I get an attorney and can I reapply? Yes, but under this regulation, if you lose, you get nothing for attorney's fees. How many attorneys are going to retain a client on a reconsideration where they're going to get zero if they lose? And if they go to the appellate division and they lose, they get zero.
I think, counsel, what I'm struggling with here, though, is there does seem to be, I think Judge Fahey was speaking to this earlier, some flexibility built into the language of the statute, a reasonable amount here. And we can disagree on what that means. But I think the court has been hesitant to jump into that dispute or policy call where there's authorization that gives the agency some flexibility. And it seems to me it has to be particularly clear that it's a violation. And once it's not authorized, and once you accept that and I take your point on reasonableness and the legal definition of reasonableness with respect to fees, but it becomes harder to line draw, I think, for this court once we accept some level of flexibility at the agency level to determine what's reasonable. And I think that's what we're struggling with here.
I guess I would respond.
Go ahead, Mr. Carpinello. You finish.
I guess I would, thank you, Your Honor. I guess I would respond by saying, how else is the legislature supposed to say that you're entitled to fees up to $1,000? Of course, they're going to limit it to reasonable because they don't want an automatic right to get fees based upon the facts of the individual case. Just like Article 86 says, you get reasonable fees. That doesn't mean you can say there's a whole category of cases. If some judge in New York City said, there's a whole category of cases I'm not going to give any fees to, because as a matter of category, I don't agree with that. Unless you want the legislature to say, when we say $1,000, we mean $1,000. We don't mean you can do this. We don't mean you can do that. The legislative director.
Can I follow up with just a point here from Mr. Carpinello? Thank you. It seems to me in listening to the arguments that we're really talking about the way we determine what is reasonable. Is it a blanket determination by the type of claim that's brought, or a blanket determination made initially by the agency for all of a certain kind of a claim? Or is it a determination that must be made on an individual basis for each claim that's made on the basis of the fees? Not on the basis of the claim, but on the basis of the fees. And I'd like you to address that, Mr. Carpinello, and then Mr. Demuth, when you get a chance, if you could tell me what you think about narrowing this question down. Is it really the question of how we determine the application of the word reasonable? Is it a case-by-case basis, or does it go to categories? Mr. Carpinello?
First, let me say it's got to be on a case-by-case basis. That's traditionally the way. Any statute that provides for award of fees and talks about reasonable fees expects there to be a determination based on a number of factors. In fact, if you look at this agency's own regulation. It has, in subsection D of the regulation they changed, it lists 12 factors to look at. And they ignored that and said, we're going to have a blanket rule that covers all the cases. Let me also say that you have to look at this case in context. For 40 years, they had no problem assigning fees on an individual basis. What happened? In 2015, a law firm down in Staten Island started advertising to represent victims of crimes. It was extremely successful in submitting claims, and the agency didn't like it. And what they did, and this is undisputed in the record, is they started calling the clients of this law firm and threatening them with liens wrongfully if they continued to be represented by this client. And it was in that context that this agency finally, they finally decided, because it was so much more administratively efficient, to have this blanket rule. What did it do? It designed to put the Gordon firm out of business. And at the same time, they filed a claim with the second department against the firm for alleged violations of ethics, which were—
Judge, if I may ask a question, please.
Judge Rivera.
Counsel, I just want to circle back to a question asked by Judge Garcia. I'm going to put a slightly different spin on it. He asked if they just said, look, for filling out the form, you get $50, caps at $50, no more than that. And you said, no, that would not be acceptable. What if they looked at what they have otherwise paid, looking at all of the factors for that process of applying for compensation, and determined that it falls within a range? And that's why they reach a particular number, but they allow for anyone to request above that number if they can substantiate the request. Why wouldn't that be a way of thinking about the exercise of their authority and how they can determine what is reasonable based on their experience without, as you point out, eliminating an entire class of fees?
And if I understand your question, in other words, if they adopted a regulation that said, where claims are within this range, we're going to allow an attorney's fee of X. Within this range, we're going to tell an attorney's fee of Y.
Correct.
Okay. Well, first of all, the lower court already held, they did that, in fact. They said, well, in a more butchered way, they said, you're never going to get a fee larger than the award, not larger than the victim award. The courts below said, and the state did not challenge this, said that's ultra vires. There's nothing in the statute that allows you to do that. And let me just also add that there's no direct relationship between the amount of the award and the difficulty of the form or the reasonableness of the fee. You may vindicate a person's very important rights by getting $250 for their watch, and it may cost the attorney 5 hours to do that or 10 hours to do that.
Well, I understood your point before, that whatever one may think about what on its face appears to be the simple, accessible aspects of the form, there is a great deal of work and research that may go behind that to ensure you have properly represented the client.
Absolutely.
And the fact that a client, if they would do it on their own and was successful, doesn't mean that they were successful at getting the full amount that they could have because they did it on their own. So I understood all of that point, but I am finding it difficult to understand sort of your pushback on this, that if they relied on their experience and expertise to choose a range, but nevertheless allowed an attorney to argue for more if they could show, as you say, look, this took X number of hours because we had to do this and we had to do that. Why wouldn't that, again, be within the scope of the authority and within the spirit of what the legislature is trying to do? Because in part, through attorney's fees, you're trying to encourage lawyers, whatever the agency may think, you're trying to encourage lawyers to do this. That's the point.
And they're actively trying to discourage lawyers from doing this. That's the genesis of the rule. But I'd have to see the guideline because I'm not sure.
Mr. Carpinello, why would they want to discourage giving awards to help victims? I don't understand the premise of the argument that the office is out to do harm to the very victims that they're assigned to protect. That's their whole purpose. Why? I don't understand the.
They're out to put the law firms out of the business of doing it.
Why?
Well, you'd have to ask them, but I think they said in their papers, or they said right in their papers, we like the VAPs. We think they're better than private lawyers. We think this is not an economic relief act for lawyers. They didn't like the fact that this law firm was doing this and they had to award fees to the lawyers. And again, keep in mind, Judge Rivera and Judge Stein, we're talking about $1,000 maximum, even if you have to take this case to the appellate division.
But Mr. Carpinello, is it not reasonable for the agency to consider the assignment of dear taxpayer dollars to the substance of to the actual harm that is attempted to be recovered by the crime victim, as opposed to, maybe in their view, they don't want to line lawyers' pockets? Is that not a?
No, I think first of all, any system that sets up an award of attorney's fees is designed to encourage lawyers to help the victims. So I don't think there's a dichotomy between helping the lawyers and helping the victims. There is.
Thank you, counsel.
Chief, I'm sorry, I have a couple of questions, if I might.
For Mr. Carpinello?
Yes, for Mr.
Certainly.
Carpinello, yes.
Yeah.
So first, let me vary Judge Garcia's question a little bit. Suppose the intake form instead just said, provide your name, address, and phone number. That was it, and we'll contact you for all the additional information. And the agency promulgated a rule saying you can't get attorney's fees for filling out that form. Do they have the statutory authority to do that?
Yes, because I don't think you need legal advice to get your name, address, and phone number, unlike these.
So in some measure, the statutory advice turns on either your, I guess, or the agency's determination as to the necessity of legal advice in completing whatever the initial form is.
Well, the legislature made the determination that you may need legal advice to file a claim, and that's what.
Well, but the legislature didn't know what the form would contain, right?
No, actually, the legislature knew very much what the form would contain because they wrote a 40-page statute that said the following people are eligible under the following circumstances with the following sections within the following time frame. And it literally take a lawyer 2 hours to 3 hours to read the statute and to figure out whether a particular claim came within the scope. That's what a lawyer has to do. And it's not filling out a 4-page form. It's figuring out whether the rights here are allowable. And the legislature realized that, when they wrote the statute, and they said,
they didn't specify what the initial form had to ask for. Is that right?
No, but they said you can get $1,000 for representing somebody in front of the board. And
right. So let me move on. Let me move on.
I'm sorry.
I've got your answer there, I think. Okay. So there's a different way, I think, to read section 626, which is it's a definitional section. And it says out-of-pocket losses shall mean, and includes a bunch of things that are within the universe of what the agency may compensate people for, but it doesn't say that the agency must do so. And just as an example, instead of focusing on the provision about attorney's fees, there's I guess it's the second sentence says that such expenses or indebtedness shall include the cost resulting from, the cost of counseling for, among other things, guardians of a homicide victim. But I take it your position is not that whatever the costs are for counseling the guardian of a homicide victim, the agency must pay those. Is that right? It can't put some restrictions around that, even though the word reasonable doesn't appear there.
Well, first, yes, they do have to pay them. They have to make a determination as to whether the claim is substantiated, and they have to pay within the limits of the statute. But if they have
whatever the claim is, even if the counseling is not legitimate, even if there's really no need for it, they can investigate that.
Certainly they can, as they can certainly do that. I mean, if they find the claim to be a fraud or illegitimate,
or unnecessary.
Or unnecessary, but they can also do that with attorneys on a case-by-case basis. But to take your example, it would be illegal for them to say, no counseling fees are going to be awarded unless you go 7 visits to a counselor. Where would you get that in the statute? That's exactly what they're saying here.
Could they say no counseling fees for guardians of homicide victims are available for more than 1 year of counseling?
Could not.
They could not.
They could not, because that's exactly my point. They cannot, because if the legislature wanted it to limit to 1 year, they would. And if and to take your question,
the way, just so I'm clear, the way you read this definitional section is it requires them to operate on a case-by-case basis, not to construct any kind of rule disallowing certain types of claims based on their experience.
Yes, they cannot make a per se rule excluding classes of people. That's because, and this court has said that in many, many cases, you cannot create a per se rule to exclude a class or to limit. For example, the statute goes into great detail about the monetary limit for medical expenses, counseling, and the board cannot say we're going to limit it to 10,000. Or to take your example, after 1 year, that would be ultra vires, just like this is ultra vires. Doesn't mean they cannot exercise reasonable judgment in an individual case, which I urge them to do, but they can't exclude a whole class.
Thank you, counsel. Mr. DeMuth, and please remain mindful of Judge Fahey's pending question.
Yes, I'll start with that. I think you said how to resolve the question. And the question is, and that's where the third department, had the most trouble, is does the statute, does reasonable fees in connection with the authority of the office to promulgate rules, does it allow them to cut out an initial stage? And I think under the standard ultra vires review, under, again, the two cases this court has never held that you could never do an exclusionary rule under any circumstances. Obviously, you get skeptical of them, but at least in Bernstein and Seghetti, you upheld those because what happens is it's basically a two-part analysis. You look at the statute, you look at the reg. Okay, maybe there's some things that aren't explicitly addressed in the statute, but is there a conflict? Is there something that's completely contradictory? There isn't anything contradictory here in 626.1, 623.3, or anywhere else in the statute. And the reg that just says, based on our experience, to which the court may not defer to the statutory interpretation, but should certainly defer to the agency experience, you do not need specialized legal services to complete a 4-page claim. A claimant does not need to internalize a 40-page statute to fill out a 4-page form, which asks, in essence, who are you, what crime was committed against you, and what injuries or loss of property did you suffer?
I think the question.
Judge Fahey?
Yeah, I think the question is whether the determination has to be made on an individual basis, case by case, based on the facts of that case, or you can make a blanket rule to say for this category, you don't need anything at all. My understanding of what you're doing is you're making a blanket determination. Normally, our application of the word reasonable as a matter of law is an objective reality for an individual, a reasonable person. And that sounds like that's not taking place in each determination. Instead, you're saying all of these are per se unreasonable, we're not doing it.
Well, per se unreasonable, and if there is a problem,
well, I guess,
they can be addressed by the victims.
I never did this. I never did this particular work. Even I worked for a carrier, I never really ran across it that much. The statute postdates my trial career, but I don't know if you had, but it seems to me that these are snowflakes. Each one of these crimes are individual to the people there. The damages are certainly individual to them. The effects of an assault on a person are different for each person. And so the claims themselves will naturally be different. And whether or not they need legal help and whether or not the fees charged for that legal help are reasonable, I'm having a hard time to understand why that wouldn't be a case-by-case determination. How you can make a rule to saying all of them are this way.
It can be a case. In fact, it has been to this point a case by determination. But the answer, all the review requires is there something in the statute that prohibits the office from using its experience and saying that we just don't see how specialized legal services are needed to complete a 4-page form.
I thought your determination of reasonableness had to do not with the type of a claim that's being made, but instead the amount of the attorney's fees to determine whether or not those fees were reasonable. Not whether or not you should have a right to an attorney, but whether or not that attorney that you have a right to is is charging you a reasonable fee.
Well, I think it's both, Your Honor. Reasonable fees.
Does it say that in the statute, or am I missing something?
Reasonable, well, no, it doesn't address in the statute, but again, silence doesn't create the conflict that the petitioners are trying to create. Reasonable fees means the amount, but it also means there's nothing preventing the office from doing what it's doing and applying it to a perfunctory initial stage of a claim where an attorney's services are not necessary.
That's the
Again,
Judge,
Spaghetti and Bernstein support
question,
that.
if I may. Judge, I have a question.
Judge
Or-
Rivera?
Or three, and then I'll be done, I think. So let me ask you first, counsel, did I correctly understand the website to mean that the only way that a victim can apply is by use of the form? Is that correct?
Yes, that's what starts the claim process to fill out, which they can do on the website, and which many do. In fact, one of the petitioners in
Okay,
this
so
case.
that's, I got your
did
answer.
fill one.
So just to quickly follow up on that. So then if I'm a victim, I go to a lawyer and the lawyer believes that they can make the strongest case and the best demand for what I want is not through the form, but through some other written documentation, you would reject it. Is that correct?
I don't know, again, the office, I think one of the judges.
Oh, I lost you. Can't hear you. I lost it. I don't hear counsel.
Had mentioned for.
Okay, well, it's going in and out.
Counsel, you're going in and out. Counsel. We can't hear you.
I'm not sure how to,
There you
Okay,
go.
you're on. You're
Now
on.
you're back.
we're back. I'm sorry, I guess to answer your question, I don't know what the office would do, but the office is traditionally very flexible. It's not like if a claimant misses information or doesn't provide the police report right away, that they always have an opportunity to submit that documentation.
Okay.
So if an attorney, no argument needs to be made at the initial stage. It's an information gathering process. But if this attorney decided to do that, I can't really say what the office would do. I don't think it would kick the claim out.
So let me ask this. Since I assume, perhaps I'm wrong, you can correct me, that the office has run the numbers and internalized the additional funds necessary so that the VAP personnel, can provide this service. You've worked those numbers, yes?
Yes.
Okay, so why can't you just use those numbers to decide what would be the appropriate amount to pay a lawyer to do it? Since you're already paying the VAP to do it.
Well, I guess they could, but the question is, that's not really the analysis here. Was it unreasonable to proceed a different route, which is to use that same experience?
Yes, but to determine whether or not you have the authority to do that, the office is relying in part on this argument that we have figured out the best way is to have these VAPs that are going to provide many services and not limited to this service. This is but one of the services. And so lawyers are unnecessary for this service because the VAPs are doing that. So all I'm saying is you've worked those numbers, you know what that amount is. If someone chooses to go to a lawyer instead, and they may do that for a variety of reasons, rather than going to a VAP, why should the lawyer not be able to be reimbursed?
I guess that's not really the question that the court needs to decide here to uphold the regulations. I understand your point that maybe they could have done it another way, but that doesn't make the way that they chose here irrational. I'm sorry.
I was just asking why they didn't do that. Okay, last question, because I had about three. Why not do it in a different way, which would be to have the rule that you have, but to allow an attorney to seek attorney's fees by showing that this is not the run-of-the-mill, what you all in your experience say is the run-of-the-mill. There's no complexity to this. You can do this easily. It doesn't take a lawyer to do this. Why not allow lawyers to make that argument? That yes, it did take a lawyer. This is how the lawyer added value to this application.
The lawyer could still make that argument. They wouldn't get, they put in the initial claim form, which even though claims may differ, the form is really still the same, basic factual information. But if they're denied, that's when you get the real attorney, the value of an attorney's services. They now have a decision in hand that a claimant may not be in the best position to find error with, but the attorney can. That's the opportunity for the attorney
Thank
do
you,
that.
counsel. Judge Stein, do you have a final question?
Yes, very quick question. Can you just clarify something for me? When it gets to a stage at which the agency has determined that counsel fees are awardable, do you apply the factors that were and continue to be in your regs to determine whether those fees are reasonable?
Yes, that's why there's no conflict, because they still apply, but for the, at the reconsideration stage. May I make one more point, Your Honor?
You may, sir. You may.
Thank you very much. Counsel for petitioners had talked about victim assistance programs having a success rate of only 50%, and as if it was proof that they're not efficient, not effective. I submit that the answer for that is obvious, because unlike a private attorney, they can't turn anyone down. They accept every person who comes to them for assistance in filling out a claim, unlike an attorney who would, of course, cherry pick their clients and find the ones who might get them the biggest payday. So the idea that they're spectacularly unsuccessful is completely false. And I'd like to point out that number, the 50% success rate, has risen significantly over the years. It's up to 65% in the fiscal year 2019-2020. And even though this year isn't over yet, there's a 71% acceptance rate. So as the VAPs improve, we will see improved representation at every point. Thank you very much.
Thank you, counsel. Thank you. The next appeal on this afternoon's calendar is appeal number 6, Green versus Esplanade Venture Partnership.
Good afternoon, Your Honor.
Good afternoon. Let's wait a moment until your colleague appears on the screen and we get Judge Feinman back.
I'm back.
Okay, great. Thank you. Good afternoon. This is appeal number 6, Green versus Esplanade. Counsel?
Good afternoon, Your Honor. Ben Rabinowitz from Gager Conason for the plaintiff appellant. Your Honor, I respectfully request 2 additional minutes for rebuttal.
You'll get 2 minutes for rebuttal, sir.
Thank you. Your Honor, in this case, the unthinkable happened back in May of 2015. And the question is whether a grandmother who was only 60 years old at the time, who witnessed her granddaughter crushed in front of her eyes, should be able to recover for the emotional damages, for the zone of danger damages.
Counsel, why is the bystander claim necessary here where the grandmother sustained her own injuries?
Because it's not just her own injuries that matter. In witnessing the death of her grandchild, as has been stated by Judge Miller below, you would go through metaphysical gymnastics trying to separate what she is feeling, the emotional trauma, in witnessing the granddaughter's death and separating that from her own emotional damages. They're all part of the same thing. And that's what the court actually spoke about in the Bovson case some 38 years ago. So when they said that you're entitled to recover for these emotional damages, for the negligent infliction of emotional distress, and they defined this by saying if you're within the immediate family, you can recover for zone of danger damages. Certainly a grandmother should be one who is in the immediate family. And the Court of Appeals has never before answered the question as to whether or not a grandmother is. But if we take a look at what has happened in the 38 years from the time that the Bovson court decided this, certainly the family structure.
Judge, if I may ask a question?
Yes.
Judge Rivera.
Thank you. So you said the court has never decided that grandparents don't fall within that immediate family, but doesn't Trombetta go against that position? Don't we have to overrule that part of Trombetta that said immediate family is limited to basically parents, siblings, and children? Don't we have to overrule that, or is there a way to avoid that?
I think you actually should be overruling the Trombetta case because it is not in keeping with the restatement of torts, which was something that was relied on when we take a look at the Bovson court, and we take a look at what really did happen. In Trombetta, you did have an aunt who raised the child, and what I'm saying is, here, if we take a look at what the restatement of torts third is saying, they're saying close family member. Every other state that has
Judge,
allowed.
May I inquire?
Please.
I'm confused. Why do we need to adopt the restatement? Now, I understand there's policy arguments about different kinds of families and all of that, but that's not what we have here. Couldn't we just fit the grandparents into our current framework, which is immediate family member within the zone of danger? And because of changes in our law, even assuming Trombetta says what you say it says, which I don't necessarily think is true, but why can't we say because of changes in our law, recognizing grandparents as a special class, why can't we do that without throwing out years and years and years of very careful, deliberate expansion of this area of law, and wait for the next case to come before us in which maybe it's not a grandparent, maybe it's something else. I don't understand why we have to take a giant step in this case when there's another way to grant relief if that's what we think is appropriate.
So, Judge Stein, you ask a very good question. I happen to agree completely with you. If we take a look at the standards set forth in Bobson, which is immediate family member, a grandmother certainly falls within immediate family member. And the reason I say that is because of the reality of today. We don't have a stay-at-home mom anymore. We have non-traditional families where the grandmothers take care of the grandchildren while the mothers work. And in fact, they're part of the immediate family. So I happen to agree completely with you. We don't have to undo that at all if we follow the immediate family member as laid out in the Bobson case itself. All I was saying with respect to the American Law Institute was when they take a look at the restatement of torts, they now have gone away from immediate family member and they say close family member.
But I happen to agree with you. Don't they also get away from the zone of danger rule when they talk about perceiving an event? And I mean, to me, that's a pretty big jump.
Well, what they're also saying is that the zone of danger for those individuals who are within the zone of danger, they certainly say that a grandparent is part of that. And they've made it very clear, just as we're saying, when you take a look at the law in New York, if you take a look at the domestic relations law, you can see immediate family member.
Chief, if I may.
Yes, Judge Simon.
Mr. Rabinowitz, I think what Judge Stein is getting at is there a way to give you the relief that you want that is incremental without eliminating the zone of danger requirement, which I think everybody concedes is satisfied here, and then leave some of these other issues to the next case? And how would you do that?
So, Judge Feynman, what I would say is this. The immediate family member, if I understand your question correctly, what you're saying is, yes, a grandparent is an immediate family member, and that would leave the law intact. And certainly what I'm saying and what Judge Stein asked, and I happen to agree completely with what Judge Stein said, yes, a grandmother is within the immediate family members, and that would certainly leave the law intact. But what we're saying is, you can't say that a title alone, grandparent, therefore we're going to say, if it was a mother, it's okay, but if it's a grandparent, no, it ignores the reality of what's going on. If, for example, a mother died during childbirth and raised by the grandparent, the grandmother, certainly that grandparent is part of the immediate family member and has to be. And that's why I happen to agree with what Judge Stein said. And
Judge, if I may ask, counsel, that sounds a lot like close family member. That sounds a lot like what the restatement third is trying to do, which is expand the understanding of nuclear family, the family that would, a family member who would most react to, as you're saying, a horrible witnessing of harm to another family member. It sounds a lot like the same thing.
I understand your question, Your Honor. And what I'm saying, Judge Rivera, is this. Yes, if you take a look at it, certainly within the standards set forth in Bobson, Susan Frierson, as a grandmother, should be able to recover for zone of danger damages. I happen to agree with you that, yes, the restatement third does expand it when they say, for example, close family member as opposed to immediate family member. I'm saying either way, in this case, this grandmother should be able to recover.
That's
Certainly.
fair. Let me ask you this. I just want to clarify with respect to your understanding of our zone of danger test and jurisprudence.
Mhm.
Does the zone of danger require that the
I lost,
Yeah.
Judge
Right.
Rivera,
Judge?
can't hear you.
I'm sorry, my apologies. Does the zone of danger test, as New York has adopted it, require, let's just take a parent to make it easy, that the parent themselves suffer an injury, or they just have to be within the zone of danger, regardless of whether or not they suffer their own injury? I just want to know your position on that.
Okay. First, I will point out that Susan Frierson, the grandmother here, did suffer an injury. But our position is it is not necessary, and I refer the court to Battaglia, for example, Battaglia versus State, where in fact emotional damages have been allowed without a physical injury, and they've updated that since the doctrine many, many years ago, 40 or 50.
Say no injury at all to the individual. If the only, let me put it this way, if the only damages that the individual is, the parent in my hypothetical, is seeking is for the emotional disturbance they suffer as a consequence of witnessing the horrendous injury or fatality to the other family member. Your
Yes.
understanding is under our zone of danger standard and jurisprudence, they can collect. They need not have any physical or emotional injury unique to themselves, correct?
That is correct. And in this case, what I'm saying is, although I say that's correct, Susan Frierson did suffer injuries to both her knee and to her ankle when that debris fell 8 stories from the negligently maintained facade on that building.
Thank you, counsel. Counsel?
Judge?
Oh, I'm sorry.
Can
Judge
I
Fre-
ask Mr. Rabinowitz, because I want to get this from
Yes.
both counsel.
Yes, of course.
What we're struggling here with is the nature of the barriers that we're trying to erect within the zone of danger and who it applies to. And is there a definition that you would point us to outside of the third restatement for immediate family that you'd want us to look at?
Yes, Your Honor. I would ask you to take a look at, for example, knowing that many of you were, for example, district attorneys or assistant DAs, or you'd worked in the criminal field. If you take a look at, for example, the penal law defining murder in the first degree, an immediate family member of a witness to a crime includes a husband, a wife, a father, a mother, a daughter, son, brother, sister, grandparent, and grandchild. It says it specifically. So what I'm saying is, if we take a look, but there's more than that. If you take a look at the election law, it says the same. Grandparent is included. The public health law, it says the same. Grandparents are included. The domestic relations law recognizes the special relationship between a grandparent and the grandchild. The rent stabilization code refers to grandparent and grandchild.
So let me ask you the next question. I get your point, but so let's say we can reach the grandparent. Actually, I find to be relatively easy. You have both a familiar, or if you wish, a genetic bond, and also a social bond that's usually pretty strong. And it's easy to include that person within the immediate family penumbra. But what about, does this mean that we would go through the process with each type of relation that maybe suffered a negligent infliction of emotional distress within the zone of danger? Let's say you come up with someone's a cousin, you come up with someone's stepsister. Do we have to go, would we go through that analysis each time? Or is there a rule we can point to that would include those kind of people, or factors that we should look at that would include those kind of people if it will be appropriate to include them within immediate family? You know, my experience with family in my lifetime is that it's changed a great deal. And when I was a young man, it was June Cleaver. Now it's Modern Family. And I think that paradigm has been reflected in all of our lives. And so I'd like us to not deal with each relative one at a time in the Court of Appeals, that we'd have some rule and some guidance for the trial court that we can offer them. I'm wondering if you have one for us.
Yes, Your Honor, I actually grew up about the same time that you did, so I understand those two analogies. That you just
Another old
drew.
man, huh?
I guess so. But my point is this. I see what you're saying, and you'd be struggling with a qualitative analysis where we try and evaluate the quality of the relationship for each specific case. In other words, let's look at the quality, let's look at the integrity of that relationship. I'm saying we don't even have to do that here, because here we do have a grandmother who is within the immediate family, which is what Bobson said originally. And I'm saying if we take a look at that, certainly this grandmother falls within the immediate family. We don't even have to go to the third restatement of torts. We don't have to go to a qualitative analysis to determine whether or not the quality of that relationship.
And how do we as a court deal with that problem of each individual family relationship that over time may fall within negligent infliction of emotional distress claim? They have damages, they're within the zone of danger. How is there a way to do that so that we don't have to relitigate this every single time there's a different familiar relationship that we're confronted with?
I think the way to do it is to get away from the title if you really wanted to. And instead of saying the title, let's take a look at the nature and the extent of the relationship. Let's take a look at the quality of that relationship, and let's take a look at the integrity of that relationship. Because whether you choose to call it a grandmother, a grand person, or you choose to call it, for example, somebody who is actually there as a part of that nuclear family, are they really there? Are they really offering the quality, that integrity? Is it part of that relationship? And I think,
Chief, if I may follow up,
Fine.
if that becomes the rule, then you basically could never grant summary judgment on the relationship because by definition, those are all going to be fact-intensive inquiries, correct?
I understand your question, Judge Feynman, and the answer to your question is yes. I'm saying here we don't even have to do that because Susan Frierson.
I understand this case, but Judge Fahey is
yes.
getting to trying to create a more general rule of general applicability. And so what I'm trying to figure out, if there's some sort of rule that provides guidance, but allows courts to weed out either at the motion to dismiss or the summary judgment stage, those claims that maybe shouldn't go to a jury. The way I understand your articulation of the rule, summary judgment would have to be denied in every single case, or the motion to dismiss would have to be denied in every case.
That I believe is why the restatement actually went to close family member to answer the exact question that you're asking right now. Because what they're saying is here, take a look at that relationship. Are they close? What I'm saying is here in our case, with Susan Frierson witnessing the death of Greta, who was 2 years old when she was 60, I'm saying you don't even have to go that far. But certainly, if you follow the restatement, which is what the Bobson Court did some 38 years ago, the restatement now says close family member, and every other state that follows it
Chief, may I ask
allows
a question?
grandmothers.
I know we're over time. Chief, may I ask a question? I know we're over.
Yes, Judge Garcia, please.
Counsel, I think with that kind of summing up here, it goes back to what Judge Rivera, I think, was getting at in very early stage of this argument, which is you keep talking about Bovson, but the only marker this court has laid down since Bovson was really a case that pulled that back in a way and reemphasized the need to Trombetta to limit that type of liability. So what you're asking us to do, I think, as Judge Rivera was saying, is really overrule the one marker that came out 10 years after Bovson, which unanimously, and Bovson, as Trombetta says, was a very closely divided court, but Trombetta 7-0 said, we have to really be circumspect in expanding this type of liability. And I think if it didn't do anything else, really closed off that kind of functional look at what role do you play in a family structure and when categories. Now, I take Judge Fahey's point in your answer that may have changed over time, but the only case it seems to me this court has decided since Bovson put an end to that type of analysis.
So Judge Garcia, I'll answer it this way. Yes, Trombetta was 28 years ago, and you did anticipate this in your question to me, and I respect that, where you said the family has changed, and it has. And that's why the restatement has actually said we have to look at We have to look at the
We
close family
rejected
relationship.
Pretty much that argument in Trombetta, because the argument was made there that I think it was a niece and an aunt, that was in essence a mother-daughter or a type of close family relationship that was similar to what we had said was okay in Bovson. And I think we rejected that. So I think your argument though now is we shouldn't reject that type of functional test, but it seems for policy reasons, that's exactly what we rejected. It wasn't that we said that doesn't happen. It was we said we were not going to consider that for liability here.
So once again, I go back to the point that this is a grandmother, that was an aunt. But even with the aunt, I am saying with the things that have changed in the last 28 years since Trombetta was decided, yes, we now have very different family structures. And because of that, what I am saying is that the law has to change and has to keep up.
Wouldn't that argue for even more of an adherence to Trombetta? Because now you have an expanded pool who under a functional test, what role do you play with respect to this person? And does it emulate a father, son, mother, son? Now we have a larger pool of potential candidates. And if you go to Trombetta saying, there are very strong policy reasons to limit this liability, then your argument to me makes the Trombetta court's point stronger. Yes, there's even more people that could potentially qualify now.
I'm saying here specifically, this grandmother does qualify under Bovson as it was written. But I am also saying that certainly what happened in Trombetta with an aunt who was a de facto mother, we shouldn't just look at the title of somebody being an aunt or an uncle or a stepmother. What I am saying is let's take a look at the relationship and let's take a look at the integrity of that relationship, because that's terribly important. And when something happens like this, there has to be a remedy under the law, because otherwise it would result in such injustice not to be able to do this. This is something that is terribly, terribly important, where, for example, this grandmother witnesses her grandchild crushed in front of her. They did nothing wrong, nothing to cause this, but the defendants submit a false inspection report.
Counsel, we understand, and the facts in this case are compelling, but as I think Judge Fahey has been pointing out, we're looking to make a rule here. So, we have to consider, the landscape well beyond the compelling facts that you're arguing to us now.
So I would suggest.
Thank you, counsel. Counsel?
Good afternoon. May it please the court, Jonathan Schaub for the respondent, Esplanade Venture Partnership. I'd like to begin where Mr. Rabinowitz left off with the idea that this is an open question that grandparents are included in the immediate family test. It's not. Trombetta, as Judge Rivera noted, limited immediate family to parents, spouses, and children. So proceeding from that point, what Mr. Rabinowitz is asking us to do is expand the orbit of duty in a carefully and narrowly recognized area of the law that this court has taken great pains to circumscribe liability.
Let me ask you, can I ask something, Judge?
Yes, please.
Mr. Schaub, what would the public policy reason be to not include a grandmother as part of an immediate family?
So the issue here becomes this court drew a boundary at a very logical.
No, I understand that, but let's address this case. Let's just say that we don't adopt the third restatement, but we do consider whether or not the grandmother is included within the immediate family jurisprudence of this court. What public policy reason would there be for us not to include a grandparent, forgetting the individual?
So what we're doing here now is expanding the class of plaintiffs who can recover from, right now you have one spouse, two parents. And what that is now doing is doubling the number of people who can recover.
I get that. I get the numbers, but the normal public policy reasons that oppose this kind of action are flood of litigation is claimed, emotional damages that can be faked. The damages are speculative. I find no evidence of that. I don't think there's a state you can point to or empirical proof for any flood of litigation that takes place by an expansion of this particular right to recover. And there was none that anyone's offered as an argument in this case. Emotional damages can be faked. That's a 19th century notion that is really outside of our jurisprudence. And things like PTSD should have really cured any court of ever thinking that emotional damages can be faked and they don't really exist. So I guess what I'm saying is just limit it to the grandmother or the grandparents. How would this affect any of those normal public policy arguments against this?
So I think the problem becomes if you start at grandparents and you've moved the field of those core relationships, there's no limiting principle.
So it's the thin edge of the wedge kind of argument. Is that, is that what you're saying?
It's a slippery slope. And I would add in the other jurisdiction.
Can I question
It's fine.
on that? Counselor, would you agree that at least insofar as our fairly recent decision in Suarez is concerned, that we have given grandparents a special status in relation to children, to grandchildren? So wouldn't that possibly be a limiting factor?
So the status that the grandparents have been afforded as it relates to grandchildren is as it relates to the best welfare of the child. We're talking about tort duties here, and in defining tort duties.
I understand, but in talking about what one has to do to get custody, as opposed to a parent. We specifically recognize the special relationship that grandparents have in our society today, and so on and so forth. So, you know, I don't think it's just limited to the best interest of the child. We made a statement about the role that grandparents play, and it's really not, you know, it's not a huge step.
I do not disagree that grandparents play an important role in the modern society. In fact, my parents are watching my children right now. I completely agree with that and understand that. But the point is that relationship and that special relationship is still not akin to the relationship between a spouse, a parent, and a child. And those are recognized and afforded constitutional protections. And if we start going down the road of looking at what statutes and cases have said, it will not be very long until the next plaintiff comes in pointing to some piece of legislation or some language in the decision saying there's a special relationship. And this builds on another point. The legislature has considered this exact issue on 3 separate occasions and considered bills to modify the general obligations law and the CPLR to include grandparents as immediate family members. And on each and every one of those occasions, the bill is not passed, which demonstrates that they're not immediate family members. For purposes of
it may demonstrate a lot of different things, but the definition and even the category of immediate family member in this context has always come from the court. So you know, I don't know that I agree with you that this is a matter that the legislature has to address in order.
Respectfully, Your Honor, this court has recognized, though, in areas of public policy with expansive potential for liability, that it is oftentimes with economic ramifications, it is best left to the legislature to decide this. And I think this court, with all—
Well, but you could also say conversely that if the legislature didn't want this to be, the legislature could limit it.
Correct, but as it exists now, there was the Guan case, which shows that grandparents were not recognized as grandparents. And in the face of that decision, the legislature has failed to pass this legislation. So legislative inactivity is evidence that it is, or in this case, it is activity, it's the failure to pass it. It is evidence of the fact that the legislature is happy with where— I'm sorry, it's happy with where the line's been drawn.
Yeah, I want to turn to a different issue, which is if you can comment on something that came up in the discussion with Mr. Rabinowitz about in a situation like this, where there actually has been injury to the grandmother, how does a court go about talking to a jury about, and this goes back, I think, also to the Chief's very original question in this argument, the emotional damages that, you know, she may have suffered for her own injury versus the emotional damages that she suffered because of what she witnessed the grandchild go through. I mean, you know, she gets up on the stand and she testifies, I'm depressed, I have insomnia, I can't sleep. You know, sometimes I dream about my granddaughter and then relive the accident. Oh no, you can't consider that. But practically, you know, how does that work?
So I think as a practical matter, this goes to the issue of the trial judge's gatekeeper function, and the evidence relating to that would not be admissible. It would, the testimony relating to this would be limited to her specific damages, unrelated to those involving the death of.
So what if she says, I'm insomniac now and I'm depressed, and doesn't talk about, you know, I'm dreaming about the granddaughter? Does the judge have to give an instruction? You can only consider that as a relation to her own self, but don't think about the granddaughter. I mean,
but I mean, there would be arguments.
The parsing is that I'm having.
So, but in that circumstance, there are always situations where the court limits the testimony, and our system is built on the notion that the jury can follow instructions. If we abandon that idea and that principle, there's far-reaching implications, and that is not to say that we don't consider the jury's ability to follow jury instructions. I don't think that would be a problem, and I think this idea that they may be led down the path is avoidable if the evidence, and the trial judge carefully monitors the evidence and the argument that counsel makes in openings and summations. This really shouldn't be an issue that comes up.
So one last question from me anyway, which is there any data, you know, you're making the floodgates or the wedge argument, but is there any data with all these other states, you know, and I'm sure you've also done the 50-state survey, and obviously the rules are a little different in many different states. But is there any data to really support this notion of we're going to have, you know, an overwhelming tidal wave now of new claims?
So I think the issue is New York State.
Assuming, for my question, that we maintain the zone of danger, which, you know, obviously is not an issue in this case.
So I think first to answer your last question, Trombetta has said that the immediate family test is the key to avoiding the proliferation of claims, and it is the key to avoid enmeshing this court.
What if they were wrong? That's my point. What's the data? What's the data? What's going on in the other states?
Well, I don't think the other states serve as an accurate proxy, because New York is different qualitatively and quantitatively than other states in terms of litigation loads and litigiousness overall.
But is there a big problem in California?
What?
California is certainly bigger than New York. What's going on there?
But California had this kind of flexible notion of a test, and that was the Dillon case, and it had to abandon the flexible test because in Thing it said it created an unmanageable load of cases where there was no ability for defendants to understand what activity would trigger liability, and created unworkable rules for courts. The other problem with trying to draw this type of analogy is, as you've identified, is the disparate nature of this type of claim across many jurisdictions. So there are other jurisdictions that impose more rigorous rules. For example, that you have to have a physical impact or manifestation of a physical injury. Another example is New York says the injury is serious and verifiable, and other states require a far more robust showing to recover for this, being clear and convincing evidence or a severe injury. So it's hard to draw these analogies when we're not comparing tests that states pick different points at which to limit the claim. New York has picked a very rational place at this line.
Judge, if I may ask a question. Judge. So counsel, your arguments are very much in the well-traversed vein of the concerns about liability and torts, right? A robust tort area or something else. So hasn't New York, though, already made a decision through the way we limit this liability to address those concerns? And more importantly, aren't we really talking about a very small class, even if you expanded it, even if you went as far as the third restatement? Bystander liability, by the mere fact that you're going to keep it limited in some way, to someone who has a connection to the family. It's not really a pure bystander in the sense of a stranger. We're not talking about strangers being able to collect. Aren't you really already talking about such a small number of cases? This is not really the kind of area that those arguments you're making that are valid arguments in terms of torts writ large really don't make sense here.
So I think that these are the arguments, they do have application here, and Judge Kaye thoughtfully and cogently laid them out in the Bobson dissent in a manner far better than I'll be able to articulate. And it was again articulated in Trombetta that this is a concern with the proliferation of claims here. But separate and apart from that, if we're talking about the relationships here, without an objective standard here, the court will now be in the business of measuring closeness of relationships.
No, but no. But if we're just going to stick with sort of someone who is not a stranger, has some family relationship, the reality is that there is, since 1993, when Trombetta's decided, since 84, when Bobson has decided, we can look to the other states. We can look to what else is going on. And you are not incorrect about California, but California didn't then adopt the kind of test that you're advocating for. I mean, California does have a much broader test than we do. So again, we can look to them, and the sky hasn't fallen.
But again, I think that it was a concern that was articulated earlier, and I think it may have been by Judge Fahey, that there's now no ability to limit these claims in any type of efficient way here, be it on summary judgment, because if we're going to look at the closeness of every single relationship, which is what California does, then that is going to enmesh the court in the business of, and on a case-by-case basis, determining whether someone is close with a particular family member, and that's just not going to be amenable to summary judgment, and it's going to create an unworkable burden on the
court. And I'm not sure that I may not share the same concerns about that, given that in the area of torts, so much is not appropriate for a judge to resolve on a motion to dismiss or summary judgment as it stands. It is usually a question of fact that goes to the trier of fact. So I don't know that I share that concern, but I understand your point. Thank you.
Thank you, counsel. Counsel?
Good afternoon, Your Honors. Catherine Herr Solomon of Marl-Lingna Party on behalf of the defendant respondents Blueprints Engineering and Maksud Faruqi. The appellate division's order should be affirmed because there's no compelling reason for this court to stray from its precedent. Trombetta is the deciding case, and it limited the recovery to the immediate the married or those related in the first degree of consanguinity. The court, it already considered the competing policy considerations, and it had to, the result is the drawing of this line. And yes, there will be plaintiffs on the other side of the line, but
so you don't, Chief, if I may. Your position is that nothing's changed in the last 30 years about society's view of non-traditional families and others, and that it's still okay to limit recovery to spouses and first-degree blood relatives.
Yeah.
That's your position?
Yes, I mean, it's...
And yet, we've done so many things in other areas of the law. So how does that promote the average person's understanding of who is a close family member or who should be considered part of the immediate family, whichever term you want to use?
It's this ruling is not, shouldn't be viewed as a statement of the importance of a particular family member. It's where it's the competing policy limits. The plaintiffs have been permitted this bystander recovery, and at the same time, the defendants there's a control on the degree of liability. I mean, what was ignored by the appellate division dissent is that every time the court expands liability, it expands the cost, and that cost is ultimately felt by the public.
Judge, if I may ask.
Rivera?
Yes, thank you. So, yes, I get your point, counsel, that the defendant always seeks to pass it off to someone else. I understand that point. But here what I wanted to ask you is, under your understanding of our jurisprudence, are domestic partners covered? Could a domestic partner bring such a claim?
I would, under the current state, if they adopted the child, or I guess you mean domestic partners of each other.
Let's
That
just say what
wanted to
domestic
find-
partner. Correct. Not talking about children now.
If they would be considered married under the law, then they would be.
No, they don't marry, but they're
They're not
domestic
married.
partners. That's the point.
Then no, under the current state of the law.
Are stepchildren covered?
No.
No. Okay. So even though the kinds of family connections I've just identified are, first of all, as close as you get to the other legally recognized or biological connection, and in other ways the law has recognized them, you would say, no, this is just a married couple during the marriage, I assume after divorce they don't count, right? It has to be the married spouses, siblings, and their children.
Right.
Does it include the spouse of the sibling?
Who is the injured
Or why
party?
does that matter?
Well, because if it's the sibling and the spouse, they're married. So they would be covered.
No, I'm sorry. The spouse, if it's the parent of the sibling.
Oh, so the father-in-law, in other words. Or
Yeah,
the
the
mother-in-law.
in-laws. That's a good way. Thank you.
No, because it's not within if they're not married or within the first degree. And I understand that it's arbitrary, but that's a product of the analysis and the defining the
Yes,
scope
and that again is, I understand your point. Your focus, and the council spoke before you, is we've got to limit liability, draw the arbitrary line, even if there's arbitrary and there's arbitrary, right? There's arbitrary where you just say, look, that's where the line has got to be drawn. And then there's arbitrary that is rather jagged because what you're doing is eliminating people that in any logical sense are included. In my example, spouses could be your defining line, but it makes no sense to keep out domestic partners if they are treated like spouses in every other way, right? That
Right.
to me is the difference between the real raw arbitrariness of something and an arbitrariness that has a function, that is to limit liability for a particular purpose. But I thank you.
Right. I would just also say that in most of these cases, the plaintiff has other items of damages that they can recover. So that in most cases, they're not precluded from full recovery. And I think that the reasoning in Trombetta in limiting liability and limiting the cost to ultimately the public is even more relevant today when multi-million-dollar verdicts are now commonplace.
Well,
Thank you,
if I
counsel.
may- I'm sorry.
Yeah, Your
Mr.
Honor.
Rabinowitz?
Thank you, Your Honor. Thank you, Judge DeFiore. I want to start with what Judge Stein said, and that was that grandparents enjoy a very special relationship because that factors into exactly what Judge Fahey said when he asked the question, what is the public policy reason to exclude grandparents? And there was no answer to that. And there is no answer to that. As far as the flood of litigation, there cannot be a flood of litigation. And the reason is this is not a separate action in and of itself. It's merely another cause of action to be added. It will add no cost at all.
Let me ask a question. I appreciate what you're saying about grandparents, but I'm hard pressed to believe that in 1993, when Trombetta was decided, people didn't appreciate, and as a society, we didn't appreciate the role of grandparents.
So what I'm saying is this, grandparents should obviously be part of the immediate family. I don't even have to go to the restatement third. But what I am saying also is, to answer the questions that you were asking, Judge Rivera, about, for example, the partners, yes, they should be able to recover. They certainly should be able to recover if, in fact, they suffered zone of danger damages that were negligently inflicted. That negligent infliction of emotional distress has to be redressed. And tort law actually does allow for redress in our courts. That's why Broadnax, the Court of Appeals, actually carved out a common law exception. They actually said, we need to solve this, and we have to solve it, and they did. And this court actually did solve that problem. So what I'm saying here is, yes, grandparents do play a terribly important role in the lives of their grandchildren. And yes, as time has moved by, things have changed tremendously. If you take a look at, for example, gay marriages are now recognized, and they should be. But to say what happened 40 years ago, to try and voice that type of reasoning in today's world does not work. And that's why we're saying here, certainly, there should be a remedy for a grandmother who witnesses her granddaughter crushed in front of her eyes. And they should be able to recover.
Thank you,
Your Honor.
counsel. The next appeal on this afternoon's calendar is the people of the state of New York versus Frederick Badji, appeal number 7. Good afternoon, counsel. This is appeal number 7, the people of the state of New York versus Frederick Badji. Counsel?
Ferguson, you're muted.
Sorry, I have to unmute myself. I thought it was going to be done automatically. Good afternoon, Your Honors. Harold Ferguson for appellant Frederick Badji. We asked for 2 minutes in rebuttal in this particular case.
Sir.
This case presents this court the opportunity to remedy the jurisdictional split between the first and second department on whether or not for grand larceny of a credit card, one needs to have the physical card or simply the numbers on the card. We believe that the analysis done by the second department in Louis C. is the correct analysis, and that when the legislature added 511A to the general business law, they did not cross-reference that to the penal law. And in fact, when the sponsor of that particular legislation made in his memorandum, he stated that Section 511A is created in the general business law, provided that only for the purposes of the general business law, the term credit card should also mean any number assigned to a credit card. It does not.
Chief Judge, if I might ask a question.
Garcia.
If they, instead of creating this 511-A, had put this language in 511 as a separate sub-paragraph, let's say 14 or whatever they're up to there, you would agree then it would apply?
Absolutely, Your Honor.
Okay.
That what you had, that
but let me take that a step further then. Okay. So let's say the criminal law, the larceny statute, cross-references in that case, where they've dropped it in as 14, 511A1, would it apply?
If the penal law included 511A1, absolutely, but it doesn't.
Even though it specifies 511A1 and the new language is in 511A14, your view would be in that case, you would use the expanded definition of credit card.
Yes, because that would be an amendment to 511, not a separate and distinct statute.
But that separate and distinct statute says it applies to the article. So I'm having some trouble seeing the difference between dropping that language as a subsection in 511 with a specific reference in the penal law to 511A1 and dropping it into a different section number 511-A. It seems to me it's just defining a subterm in 511A1.
No, because it says in 511A, for purposes of this article.
And what does that mean?
It means Article 29A, which references the general business law. It does not cross-reference it to Title J.
But aren't we getting into a very strange area then? Because they're referencing in the penal law this definition. And that definition has sub-definitions in a way. But what you want to do is limit the cross-reference without the sub-definition. And
Your
that
Honor.
strikes me as leading down a somewhat strange road.
No, it's not a strange road because remember, all of this is happening in 2002. At the same time that the general business law adds this section, at that same time, the legislature also created a series of penal law provisions directly dealing with the situation presented in Mr. Baji's case. Specifically, Penal Law 19081 says a person is guilty of unlawful possession of personal identification information in the third degree when he or she knowingly possesses and then references the numbers on the credit card. Here, what you had simply
Judge,
was...
May I inquire?
It's done.
Yes.
But, so 190.81 is clearly a possession statute, right? And we're talking about theft. My concern, my problem is that I think we're creating this difference in various types of crimes throughout the penal law, whether they're possession crimes or theft crimes. And we're just leaving this one out, which just isn't consistent with what I understood and what I think we previously said was the purpose of the amendments, which was to recognize that a lot of these crimes are taking place without actually getting hold of the actual credit cards. So I think my concern is that it leads to a lot of inconsistencies, and it doesn't reflect the fact that possession is different from theft.
Your Honor, but the reality is that when you have the number alone and use it, that's the theft. We have that. The possession of it, knowing that you're going to use it, that's criminalized in 2002. What you have here is that in reality, the legislature poorly drafted 511A. And when you look at the sponsor's memorandum, it can't be more specific than what the sponsor said, that it only refers to the general business law. It does not apply to anything else. And since all of these things are being done contemporaneously.
But 511 says that as well, right?
511 refers to tangible property.
No, 511 says only for purposes of general business law. And 511 is included in Article 22 when 511A says that it's only for purposes of the general business law. So the multiple cross references there or inclusions there, I think make your argument a little difficult.
I respectfully disagree, Your Honor, because again, you have to look at what's going on contemporaneously in 2002, and that is that the legislature is comprehensively trying to deal with these problems. And if they had wanted to, they simply could have amended the penal law as it related to theft of a credit card to cross-reference 511A. They don't do that. Instead, they add
a question, if I'm asking.
Yes, Judge Rivera.
So, counsel, I just want to be clear. Under your interpretation of these various sections and the statutes, these various statutes at play here, what could a person who steals the card and then uses the card be charged with?
The person who steals the card and uses the card is charged with the theft of the card and also the use of the card. It's our position that if a person...
I'm sorry, so just to be clear before you move on, I'm sorry.
Right.
Just to be clear, I just want to understand this. So they would be liable under, or they would be criminally liable or could be prosecuted under both the larceny statutes as well as the identity theft, the personal identifying information statutes? Is that your position?
Absolutely, Your Honor.
Okay, so they could be liable for different kinds of felonies and depending on the facts, maybe only a misdemeanor on the unlawful possession of the personal identifying information, i.e. the credit card number.
That's correct, Your Honor.
Okay, I'm sorry, I interrupted you. I don't know if you want
And
to
that
add.
and again, because they're dealing with this all at the same time, and they certainly could have. It's a problem of drafting. Here, the legislature had the opportunity to cross-reference it to Title J. They did not. They did not cross-reference it to the penal law. The penal law refers to 511. They did not amend the penal law to say that it covers 511A. Therefore, it's our position that this situation, possessing simply the numbers, is not in and of itself a criminal offense.
Can I just follow up on that point, Mr. Ferguson?
Yes,
Judge,
Your Honor.
all right. Yeah, thank you. I guess what I'm struggling with is the logic of the position, maybe on both sides. It seems to me that a plastic card without numbers on it is not a credit card. However, I can go on the internet just using my numbers and buy anything I want up to my credit limit. And that the essential element, the sine qua non, to quote our Latin teachers, is the number on the credit card. And the use of that number seems to me to be the criminal act, the act of theft. And the possession of that number is also what constitutes possession for purposes of knowingly possessed. I guess the question has to be, is it essential that you have both the plastic card and the number to be charged with the crime? Because it is not essential for, as we all know, to use that number in a variety of formats, and the card is totally unnecessary.
But when they amended the statute to create a charge for a felony for possession of a credit card and the theft of a credit card, it was to deal with the valuation issue, because it really had no value as just as a plastic piece.
No,
And
but
so
it did have, let me just
Governor
stop you there,
Rockefeller-
Mr. Ferguson.
Yeah.
It did have a value as a number. What's happened though is that commerce has changed, and the number is all you really need to exercise your commercial rights to someone else's credit.
Again, that's absolutely true, Your Honor. But again, what we're getting back to is how this statute is written. And the basic canons of statutory construction are that you go by the plain language of the statute. And the plain language of the statute here indicates that you need the tangible card for it to be this particular crime, not simply the numbers. And we believe that the analysis, the detailed analysis taken by the Second Department in Louis C.
Judge, if I may ask another question. Counsel, what, if any, meaning do you give to the fact that in 155.00 for both credit card and debit card, but I know we're dealing with a credit card here, it says that the credit card means any instrument or article. What, if anything, what, if any, meaning does that carry for this analysis?
All of it goes to that it was a tangible, something that is tangible. When you say article, when you say card, it all is tangible property, something that can be physically held. The number itself is not enough.
Thank you, counsel. Counsel?
Good afternoon, Your Honors. Michael Yetter for the People. In 2002, the legislature realized the 1962 definition of credit card was no longer added.
Counsel, we're having some
Counsel,
trouble
we're
hearing
having
you.
a little difficulty hearing you. Perhaps if you could raise the volume of your microphone, if that's possible, or maybe perhaps a little closer.
I'm sorry, can you hear me now?
Not well, but if you keep your voice elevated, I think we'll be able to.
Okay, I'm sorry about that, Your Honors.
It's okay.
The point I was trying to make is that in 2002, the definition of credit card was changed in General Business Law, Section 511A, and my opponent's complaints are basically about the way in which the amendment was done and not about the substance. I think,
Judge, if I may ask,
yes.
Counsel, it does appear, unlike Judge Garcia's version of including the language about any number associated or assigned to a credit card within 511 itself. It is a little odd to call an amendment something where you have a separate freestanding statute. I find that very odd. The legislature just doesn't do that. This is not a mere drafting error. This is absolutely intentional, and it does strike me as going against every rule of drafting. Can you explain how your position, how one explains that? And it cannot merely be an error.
No, I don't know that it was an error, Your Honor, and unfortunately, I don't think the legislature clearly stated why they went with 511-A instead of a subdivision in 511 itself, like Judge Garcia mentioned. But what they did say is, for the purposes of this article, a definition of credit card shall include any number assigned.
Well, then how do you explain what are actual enactments of that new suite of crimes dealing with personal identifying information, right, which would include a credit card number, of course, and does so in the statutes that I'm talking about in the penal law, and just at that same moment could have, of course, amended 155.007 to refer to 511-A. Again, my difficulty with your analysis is I have to ignore numerous rules of construction, and the court has to add in language to get to your analysis and your conclusion, and that's where I'm having a challenge. So tell me how we can explain that.
Well, as I think I was trying to state, Your Honor, we believe it is pretty straightforward, both from a reading of the statute sense and also from the statutory legislative history. Again, 511A says, for purposes of this article, the definition shall include credit card number. Of course, the penal law 155 sub 7 cross-references 511. We believe that 511A amends the definition that in 1962 was placed in the general business law. And we think it would be—
Let me ask you this. If let's say I agree with you on that, then how does that explain that if we read it that way, that means that credit card holders get greater protection than debit card holders? And that seems to me to run counter to what the legislature has been doing over and over again. I think Luis C., the court there, pointed to that too. How do you address that issue?
Well, the legislature did not amend 511-9 through 511A. It could have done so, but it didn't. And it might have been concerned at that time with the fact that credit cards may have seen more instances of fraud related to credit card use than debit card.
Yes, but that's my point. In that suite of new crimes, debit cards are included. So it does seem, and debit cards are added in later after credit cards throughout the penal law and the GBL. So it does seem that the legislature is trying to put the holders on equal footing. And again, your analysis, as the court in Louis C. points out, would mean that a debit card holder it doesn't get the same kind of protections. And there's not the same kind of criminalization of that bad act that there is for someone who is a credit card holder.
Right, and I think that's correct under the 2002 definition in the amendment. And I think to the extent Luis C. talks about a debit card, it's correct. But to the extent it talks about a credit card, it's not, because for whatever reason, the legislature decided that a credit card number was something that it needed to include in the larceny statutes. And it would be odd that, given the 30—
Well, it would lead to an absurd result, wouldn't it? Someone steals, looks in my wallet, writes down my credit card numbers and writes down my debit card numbers and goes about the business of using both. But under your scenario, they're only liable on the larceny statute side anyway for the credit card number. It does seem a bit odd, doesn't it?
It does seem odd today, Your Honor, and it's something that certainly is ripe for review by the legislature, but I don't think in 2002 it was necessarily that odd given the situation and the circumstances that were then present. And we do think it would be odd that, given the longstanding relationship between Section 511 of the General Business Law and Section 155 of the Penal Law, that in enacting this sort of broad legislation to combat exactly the kinds of crimes that we have here, that the legislature somehow intended to, pass these new laws that circumscribe or cabin the theft of a credit card only to a physical card, a plastic card itself.
You agree here, though, that the defendant, even though he wasn't charged with it, could have been charged with one of those identity theft provisions?
I believe, yes, that he could have been, based on his use of the credit card, both in the Uber and at the Verizon store.
So in reality, he would have suffered a great deal of criminal, he would have been exposed, let me put it that way, to significant criminal liability if we adopt the reading that defense counsel is arguing for. It's just you've got to do the correct charging.
Well, I mean, the criminal liability on the use, depends on either the dollar valuation or the number of pieces of personal identification information to bump it up. I believe here we would get into felony territory based upon the amount used at the Verizon store. It was over $500. But we just think our reading is consistent both with the text and the history of the statute. And I think, my opponents.
I agree with you. For the single theft at a very low amount, you get the person to have a felony. I think that's what you're talking about.
That's right. And I think that they work together.
But you agree that the legislature could have decided that's not the outcome they were seeking, correct? Even though you think it is, but you can agree that the legislature could have made a decision that that's not the outcome they wanted, correct?
Yes, and I think if they wanted that, they would have made it very clear given the long-standing relationship between those two statutes. So, and unless there are any further questions, we believe that the appellate division properly resolved this issue in this case and would ask you to affirm.
Thank you, counsel. Counsel?
Your Honor, both the First Department and the Second Department in Barden and in Louis C. looked at the legislative history of this particular statute, and both came to the conclusion that the legislative history pointed to the interpretation that we are advancing here. In addition, there is the principle of lenity. At best we have here is competing interpretations of what this statute means. And under those circumstances, the canons of construction indicate that the interpretation that should be held by the court is the one more favorable to the defendant, so that even under the principles of lenity, that we should prevail. And I'd like to take just a brief moment or two to address the evidentiary issues that we also raised. One of which is, I think, is very important for this court because it deals with Russell and Sanchez, and going back to a Latin term that was used in an earlier case. The question is whether the sine qua non in having an individual identify someone from a videotape is whether or not there is a changed appearance. It's our position that under Russell and Sanchez, there had to be a changed appearance. Otherwise, the jury itself, which has the opportunity throughout the trial to look at the defendant, can make a determination as to whether that person is the person depicted in the videotape.
Judge DiFiore, may I inquire?
Yes, Judge Stein.
Can't those cases be read as saying that was the reason in those particular cases why the testimony, why the identification was permitted? But I'm not sure that they can be read as saying though that is the only circumstance in which.
Your Honor, if the opinions had been written in the disjunctive, I would agree with Your Honor. But they were written in terms of the conjunctive. It was and there was a changed appearance. And I think under those circumstances, and what you're having...
But there's a broader principle involved there, and that is that it would be helped because of some circumstance. Maybe it's a changed appearance, maybe it's a poor quality photograph or video, but something makes it useful, helpful to the jury to have this person who is familiar with the person being identified to testify, to explain. And certainly a change in appearance would fall within that broader principle. but my other question is why was that, if there was error there, identity wasn't an issue here. So why does it matter in this case?
Let me go back to the problem here is how Russell and Sanchez has now been interpreted by the lower courts. As a matter of course now, individual witnesses are allowed to routinely identify people by videotapes and photographs. That can't be the purpose that this court set forth in Russell and Sanchez, that was supposed to be in exceptional circumstances. Instead, what's happened is this is happening as a matter of course now, and this court has the opportunity to correct that. And as to the issue of harm in this particular case, identity is an issue. Because there's a series of evidentiary issues here that are contained in our brief, and I'm not going to go into all the details.
I thought the defense was that he was authorized.
But what you have here is they also have to prove his identity. And the reality here is, absent these evidentiary areas that we have in our brief, there is no live witness who testifies that my client has committed any of these crimes, and that once you remove all of these evidentiary items, the overall impact of these series of evidentiary errors tainted the result and tainted the resolution of this case. And we believe that under those circumstances, this was not harmless. If it was a singular error, it was simply the videotape identification, that would be something different. But it's a series of evidentiary errors. And when they are compounded together, we believe that it becomes harmful error. Thank you, Your Honors.
Thank you.